we've been established as an agency, as a competition protection and development agency in Kazakhstan, just at the end of last year, in the fourth quarter of 2020. This agency was basically based on the previous work done on the antitrust committee that we had before. But as maybe some of you know, I've shared this with Claudia, we've been upgraded in our authority and powers to tackle cartels and antitrust practices in Kazakhstan altogether. So we've been basically directed underneath our president directly, which gives us kind of more autonomy and power to deal with antitrust issues on a daily basis. And for the first time, basically, with this COVID-19 crisis, we have tackled with issues in pharmaceutical industry. As you know, with COVID-19 and the size of our market, we import a lot of drugs into Kazakhstan from our neighborhood countries in Russia and the EU. So price hikes are pretty common in Kazakhstan. So I'm very grateful to the participants today for their time and their willingness to share with us the experiences that they have, practical cases with dealing with pharma companies and their business practices. But how I just wanted to share with you, I mean, for example, just in 2017, in our jurisdiction, as Claudio mentioned, the very first cartel that we have actually identified in our legislation was a pharma cartel. Was a pharma cartel. We in Kazakhstan have the system of whereby we have a single distributor with our Ministry of Health, for example, that buys drugs single-handedly as a single procurement agency of Ministry of Health, and then distributes it across Kazakhstan to ensure stable supplies. So in 2017, our previous colleagues who worked on this case have identified it, but I just wanted to share with you that nothing has really changed so far. And we are all working now on new cases in pharma, and I just wanted to share with you what we've been doing with the Ministry of Health in the last 3 months. It's a new dimension in our work in Kazakhstan. We use classic price regulation, price caps on drugs here in Kazakhstan. So we've managed to tackle some of the price hikes and speculation at the fourth quarter of 2020. Right in the midst of COVID-19 here in Kazakhstan. But now we're kind of in the second phase. And the second phase of this negotiations with our pharmaceutical industry, and we on a daily basis, they indirectly maybe they try to influence the decisions that we are making here in the agency. To, for example, they would one day they would say we would stop supplies into Kazakhstan because it's not an interesting market for us. The size is not that big, and the prices are too low. But when we actually analyze those prices, we've seen that the markups are way too high, marketing costs are way too high, and the bidders, they couldn't prove them. So we are still in this ongoing negotiation with the pharma industry together with our Ministry of Health. So we found ourselves in this case at the end of last year and in January this year. But we're trying to devise a program, and this is something I wanted to share with you maybe later on in our remarks, of how best to promote competition here in Kazakhstan to avoid these kind of cases, and to promote competitive business practices amongst our suppliers here through generic competition, promotion through better procurement practices of our single distributor, and obviously deregulation, as it is in especially in retail. Since 2017, we found that Ministry of Healthcare has been heavily regulating retail prices in Kazakhstan, and our studies have shown that it has not been as effective. And in this slide, you can see what we're thinking, what we're thinking about of doing here in Kazakhstan in the next couple of months through legislation, through IT systems. So this is kind of in brief what we have managed to tackle in the last couple of months as a new monopoly agency in pharmaceutical sector as well. So yes, I'm looking forward to your comments and to your inputs, and my colleagues will be happy to learn from the cases that from the speakers that we were about to hear. Thank you very much.
Okay, so thank you very much indeed, Marat. As you can see, the situation is very dynamic here in Kazakhstan. There is lots going on, both at the institutional level and an enforcement level. And there is that very interesting entanglement between an overlap sometimes between regulation and competition enforcement that makes it even more interesting. And but for our first speaker today, we fly to Europe and in particular to Italy. Our first speaker is Dr. Claudia De Sogus. She's an officer at the Italian Competition Authority, but she's also a professor at the University of Bologna. And indeed, she has that perfect blend of practical and theoretical knowledge, especially in the pharmaceutical sector, that makes her contribution extremely valuable today, because she has written books and book chapters and articles on competition enforcement in the pharma industry, but she has also been a case handler in cases regarding this industry. And indeed, today she will tackle some of the most important cases in Europe, especially regarding excessive pricing. So without further ado, please, Claudia, the floor is yours. And thank you very much again for accepting to speak today.
Good morning, good evening, good afternoon, everybody. Actually, I'm thanking you for inviting me. So shall I share my screen, right?
Yeah, sure.
Okay, can you see it?
It's still loading, but yes, now I can see it.
Okay, great. Okay, so today I'm going to present two cases dealt with by two national competition authority, European ones, the Italian and the British Competition Authority. They are pretty recent cases. They both deal with the pharma sector, obviously, and especially with excessive prices. So a brief introduction of the legal, regulatory, and also political context in which these two cases took place. Because, well, first of all, we have to start from the fact that, as most of us know, Europe is endowed with a specific provision that allows the national competition authorities as well as the Commission to tackle excessive prices differently from the US antitrust law, which does not have such a provision. The provision contained in the treaty is Article 102, letter A, which specifically prohibits dominant company from charging directly or indirectly unfair purchase or selling prices or other unfair trading conditions. The provision takes its origin on the theory that once that competition law protects consumer not only indirectly, there is by protecting competition, but also directly protecting consumers from activities of rent seeking, for instance, implemented by companies which have enough market power to do that. I must say from the very beginning that yes, there is a provision in the treaty, but as everybody says, it has been rarely applied. Most of the people who notice that say that this rare application is mainly due to practical reasons in certain cases, because it's difficult sometimes and in certain sectors to understand what is an unfair and excessive price, or it is difficult to answer the question, this price is legitimate or it is excessive with respect to what? So the main difficulty is to find a benchmark against which examining a pricing policy. But in the recent years, in the last 5 years, there was a sort of political wave of renewed interest in this provision, and we can see that from the speech, from the words pronounced by the Commissioner Vestager in 2016. In that occasion, she said that the Commission would have acted against excessive prices in order to protect consumers. But as a matter of fact, the case law of the European Commission remained, even after this statement, very, very scarce. The landmark ruling remained the very, very old United Brand case, which still provide guidance to the application of the test to understand whether a pricing policy is excessive or not. There have been some new cases, the Akala case and the Gazprom case, but the Gazprom case was concluded with commitment, so there was no application of the test actually, and the Akala was mainly a preliminary ruling, therefore it was up to the National Court to finally decide whether the pricing policy applied by this copyright collective society in Latvia was illegitimate or not. Who is very active instead is the national competition authorities in many, many countries. One of them is the Italian one, and the other one very active in this field, especially in the pharmaceutical sector, is the British Competition Authority. As you can see, there are quite some cases that have been dealt with by the CMA, by the Competition and Market Authorities. Most of these cases deal with excessive prices applied to off-patent drugs, therefore all drugs. But a new wave of cases in which we are also involved as national competition authorities deal with orphan drugs. That is, with drugs that are characterized by the coverage of a market exclusivity. It's not a patent, but still the company has a sort of like a legal, special legal status that shielded it from competition. If we have time, we can also say something about this new case, which is the Lydian case, which has been opened almost contemporaneously in 4 member states. But let's go to the Aspen case and to the Flynn case. The Aspen case is the case dealt with by the Italian Competition Authority. It was opened in 2014 and closed in 2016. And the object of the analysis of the Italian Competition Authority were the following facts. Basically, Aspen, which is a South African generic company, in 2009 bought from GSK, from Glaxo, a portfolio of anti-cancer drugs, which we are going to name Cosmos drugs for simplicity. After having acquired the Cosmos drugs, Aspen went around Europe before the European regulation and also before the Italian Medicine Agency, asking for an increase of price. Actually, what Aspen asked to the Italian Medicine Agency was to reclassify the Cosmos drug from the A class to the C class. The A class includes the drugs that are reimbursed by the state, by the national healthcare system, because these drugs are judged to be essential for the population. Whereas the C class includes the drugs that are paid out of pocket from the citizens. So it includes also non-essential drugs. So the Italian Medicine Agency was pretty against this request because it judged the Cosmos drug to be essential drugs. So it wanted to have them in the A class. It wanted to have them reimbursed by the state, because moving them to the C class would have been free pricing and probably a price hike which would be paid out of the pocket of the patients. And therefore, it rejected. Aspen insisted, but then the negotiation failed. And it also failed because the price that was proposed for the Cosmos drug, if the Italian Medicine Agency had agreed to keep them in the A class, was considered to be unbearable. So the counter proposal of the company was, okay, we keep them in the A class, but we want an increase of the price. But that increase was considered to be unsustainable for the national healthcare system. Aspen then threatened the withdrawal of the drugs from the market, and therefore, after this threat of interruption of supply, then finally the Italian Medicine Agency agreed on the new prices for the Cosmos drugs. And the new prices are indicated here in this slide. You can see that the price increase was very, very high. The highest being of more than 1,500% with respect to the old price. Okay. Based on these facts, Yes.
I'm really sorry to interrupt you. Could you please, I've received this request, could you please show the full presentation? If you click on presentazione and mostra.
Sorry, what do you?
If you can show the full presentation so that we see the Zoom.
Yes, I tried, but can you see it?
Perfect.
Yes.
Spot on. That's spot on.
Okay, because at the beginning it didn't work. Sorry about that. Okay.
No, thank you very much. Sorry for interrupting. Cheers. Thank you.
No problem. Okay, so these were the facts. So the Italian Competition Authority opened the case, and according to the Italian Competition Authority, actually Aspen adopted a very aggressive negotiation strategy against the Italian Medicine Agency to obtain actually an increase of the price, which was disguised as a request of reclassification. And also Aspen could leverage in this implementing this behavior on a loophole that characterized our pharmaceutical regulation. Basically, when the company negotiates the price with the Italian Medicine Agency, it has the possibility to market already the drug and to market it with a free price. So this increases the bargaining position of the company, because the demand for the product is already there, and it's there at a price that is decided by the company. So that price acts as a focal point for the negotiation. So this weakens the Italian Medicine Agency and strengthens the position and the market power that any pharmaceutical company has, and that in that specific case also Aspen has, because we should remember also that Aspen was in a very good position in the first place because these drugs were essential. Okay. Also, the aggressiveness of the strategy was found by the Italian Competition Authority because the company also threatened to reduce the supply or withdraw the drug from the market. Also, the price increase that was obtained through this strategy was considered to be excessive and unfair. And for this reason, Aspen was fined for having implemented an abuse of dominant position, for having charged unfair excessive prices within the meaning of Article 102, letter A, through an instrumental and distorted use of the regulation. The decision from 2016 has been upheld before both courts, first instance and second instance. And so we had the final decision from the Council of State last year in March 2020. Very similar to the Aspen case is the Flynn case dealt with by the CMA. So in 2012, Pfizer sold all the distribution rights for an anti-epilepsy medicine called epanutim to a generic company called Flynn Pharma. After this sale, Pfizer continued to manufacture the product, and it sold it to an ex-factory price that was from 8 to 17 times higher than the ex-factory price that was charging earlier. After having bought the drug, Flynn debranded the medicine. What do I mean by that? He made epanotin as a generic product. Instead of having a branded product, it genericized it. And epanotin became phenytoin sodium capsules. In the UK, when you genericize a product, or when you have a generic product, you don't have any price regulation. That is, you enjoy complete free pricing. And for this reason, Flynn was able to resell the price to the public, to the patients, at a final price that was between 25 and 27 times higher than the final price that was charged earlier by Pfizer before this. Also, this was considered to be a conduct that was abusive under Article 102, letter A by the CMA, and therefore the Pfizer and Flynn were both fined with very high fines indicated here, and for having charged unfair excessive prices. And they also ordered the company to lower the price. This decision was, however, it had less luck than the Italian one, because it was not upheld during the appeal before the first instance judge, the Competition Tribunal, which in 2018 quashed the decision for reasons that are interesting to discuss, because they raise some legal issues in relation to the application of the United brands to these cases. So just to make a long story short, we have two cases that were run in parallel by the two national competition authorities in Europe, and are very, very similar, but strangely enough ended up with a very different outcome. So you have an off-patent drug that has been purchased by a third party, which sells this off-patent drug with a very, very high new price of increasing the price of a scale of hundreds percentage. Both drugs did not have therapeutic alternatives at that time. And both conducts, that is, the increase of price, took place at the level of the distribution, at least in Aspen, whereas in Flynn it took place both at the level of distribution and manufacturing, because Pfizer kept the possibility of manufacturing the product. So very, very similar case. So what is the methodology that was used, by the national competition authorities? It is also very similar. They both started from the fact that, yes, it is true that the United Brand case, it's a landmark ruling establishing the so-called price-cost test, which you're going to see briefly right away. But it is clear from the jurisprudence of the European Court of Justice that the price-cost test established in the United Brands, it's not the methodology, it's one of the methodologies that can be used to find unfair excessive prices. And in fact, the court itself in other cases used other methodologies, such as, for instance, cross-countries comparisons. And this is the methodology that was, for instance, applied in the Akala case from 2017, which I mentioned earlier. So many methodologies, but both the CMA and the Italian Competition Authority decided to use a price cost test. So they moved along the line of the United Brand test. So what does the European Court of Justice said in the United Brands? So the court said that in order to have illegitimacy under Article 102, letter A, a pricing policy need to be not only excessive, but also unfair. So the test is made of two parts. There is the first limb, which is the excessiveness limb, and then there is the second limb, which is the unfairness limb. Excessiveness. A price is excessive whenever you have a difference between the price itself and the cost, which is excessive. And this excessiveness must be persistent and significant in time. Secondly, when an excessive price is also unfair, the court said that unfairness could be in itself or when compared to competing products. So within the second limb, you have two alternatives, two alternative prongs. What does unfairness in itself means? For instance, when the excessiveness is so much, that is the disparity between the cost and the price is so high, this by itself can be used as a proof of unfairness. Or you can use other qualitative elements that characterize the case, as we'll see in these two cases. Or you make a comparison, that is unfairness compared to other competitors. So you check whether other competitors or comparable products have the same excessiveness or not, the same disparity between cost and price. If not, this is a proof of the fact that your product has a price that is excessive and also unfair. That is, it's unfair because it is not justified by other non-cost related factors that explain why you have such a price difference, such a difference between the cost and the price, okay? So how excessiveness was calculated in Aspen? Two methods. The first one is the gross margin. So it was calculated, the difference between the ex-ante and direct cost, ex-ante prices, ex-ante before the increase, I mean, and the direct cost. The resulting gross margin in percentage of the sales was compared to the total cost in percentage of the sales. And this rendered that already before the increase in price, the old price granted to Aspen already a positive margin, very high in certain cases, because it was ranging from 20-30% to 70-80%. Therefore, after the price increase, this gross margin increased even more, ranging from 3,100% to 1,500%. And this was considered an indicia of excessiveness. Second method that was used to make the first finding robust was to use the cost plus. What is the cost plus? It's an application of the price cost test used in the United Brand case. Cost plus is what we use. It's a formulation that we use to indicate your benchmark price against which you can measure the excessiveness of a price. How do you build this benchmark? How do you build a cost plus? You sum the direct cost pertaining to the product, a portion of an indirect cost, and you sum up a so-called reasonable rate of return. So the profit that is reasonably earned by a company in the same condition in which your investigated company operates. In us, the reasonable rate of return that was found was of equal to 13%, which was the average reasonable ROS, return on sales, that was earned by the two main generic companies operating worldwide. This analysis also allowed the Italian Competition Authority to come to the conclusion that the price was excessive, because the prices charged by Aspen were excess in percentage over the benchmark, ranging from 100% to almost 400%. So this percentage were well above the percentage that were found by the European Court of Justice in United Brands and that were judged to be excessive. Same thing in Flynn with two differences. The method was just one, not two, so no robustness check, and the only method was the cost plus. And the reasonable rate of return, the CMA was much less generous with respect to the Italian Competition Authority and decided that because the drug was very old, because there was a very low risk in supply, and because was no effective competition in that area that could endanger Pfizer and Flynn's profits, the reasonable rate of return that could consider the return on sale that could be considered reasonable was of the 6%. Okay, so less than a half than the one considered by the Italian Competition Authority. And this was for what concerns the excessiveness. Unfairness in Aspen and in Flynn is basically very much similar, because both drugs had the same characteristics, although they were pertaining to two different therapeutic areas. So unfairness. Both National Competition Authority decided to resort to the notion of unfairness in itself, because they found that there were no competitor comparable products. And they did not find any non-cost related factors, any qualitative factor that could justify that excessiveness. Why? Because the products were old, they were off patent. There was no R&D effort, nor for Aspen, nor from Flynn. And at the same time, they were essential products because there was no substitutes. In fact, no competitors' products were found. And both, in both cases, the evidence gathered showed that the companies were somehow acting to misuse the limited resources of the Italian and British NHS, and they were aware of it. Okay, so very similar reason. So I will go very quick from this. Okay, so the conclusion is that in these two specific cases, the United Brand Test and the landmark ruling that characterized the European jurisprudence on excessive prices was applied in a particular way, which was most probably, and this is most probably due to the characteristics of the product, because we are speaking again of very old product, off-patent product. And for this reason, the excessiveness in itself, the disparity between the cost and the price was an element that by itself also allowed the national competition authorities to conclude that the price was also unfair. This is a sort of a truncated way to apply the United brand test established by the European Court of Justice. Of course, this truncated rule of reason analysis, which that I define in this way, does not prevent the National Competition Authority from doing checks, cross-check analysis, which is exactly what the Italian Competition Authority, in order to be on the safe side, decided to do differently from the CMA. Probably this is the reason why the outcome of the case in the UK was different, who knows. Anyhow, I'd like to just quickly conclude this presentation, which has been already too long. Sorry for taking so much time, by saying that although these cases are pretty much structured and pretty much similar and seem to pave a sort of way, still leave some questions unanswered. First of all, the fact that the Italian Competition Authority used two methods and the British one don't, and for this reason was criticized by the judge, raised the question, is one method enough or not? As a matter of the jurisprudence, as I said, the court tells us that it's not necessary to have to apply more than one method, but as a matter of robustness of the analysis, this is probably the better choice to take as a competition authority. And then other question, is there, when you define your benchmark against which you find the excessiveness of the price, does this benchmark has to be a competitive counterfactual? That is, you have to necessarily find a price that could have been charged in absence of the potentially abusive conducts. Because if this is so, then the task of finding excessiveness could become too burdensome from a competition authority, because it's very difficult to find a competitive counterfactual, because you never know how the market would have evolved, how the structure of the market would have evolved without the implementation of the conduct from the dominant company. And within this problem, the fact that we have to find a benchmark that is as much as possible realistic obliges a national competition authority to identify a specific reasonable rate of return for that specific product, or is it correct also to resort to an average, as both national competition authority did? Because the average of the sector is a measure, but might be probably unrelated to the specific product. And other questions: is it necessary? Is it enough? Is it sufficient, as I said, to have this sort of truncated rule of reason? So when you have a very, 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 very high excessiveness, a very significant excessiveness, is this enough also to find unfairness? Is it enough to resort to unfairness in itself whenever you have, differently from these two cases, the possibility to make a comparison with other products, or the jurisprudence allows the national competition authority to choose one of the two avenues? And last but not least, a very important question: how do a national competition authority measure the so-called non-cost related factors? So the qualitative aspects that might justify a certain price. Some commentators said that it is important to make reference to the willingness to pay of patients or national healthcare systems, or in general, of consumers, to understand whether that price is fair or not, is justified or not, even if excessive. Well, this is a measure that is well known within the economic theory, but I think that in the pharmaceutical sector poses a very, very important problem, because when it comes to drugs, patients are willing to pay any price if that drug, especially if that drug is essential. So this criteria cannot really translate into a practical legal test, in my view. Imagine that you are in a desert and you are thirsty and you're about to die. Whoever brings you water, you are going to pay that person an infinite price. But in that case, you will consider legitimate any price, even an infinite price that that person will charge you for that water. That means that willingness to pay is not really a criterion that can be useful for the national competition authorities to understand whether that excessive price is justified or not. So I concluded my presentation with this question, and I'd like to thank you for the attention. I hope I didn't take too much of your time, and I'm willing to take questions from you if you like. Thank you.
Well, thank you very much, Claudia, indeed, for your presentation. It's been, I took lots of notes, and it's been, I think, a lot, extremely interesting for all of us, and there was lots of food for thought. If you want, I would rather have question and answers at the end of this session for all our speakers. If I don't think that I have questions for now in the chat, but I will group them all together, because it might be possible that some questions will be addressing several presentations at the same time. And in that case, I think that we can have a Q&A session at the end. Again, thank you very much. We have we have looked with your presentation at lots of extremely important issues, from interpretive issues. And here, I think that my students will remember that the fact that I always remind them that the methods and means of interpretation sometimes, and very often actually, do shape the results. Actually, they are an integral part of the results of your investigation. And these very insightful analysis of the Flynn and Aspen cases that you have just given us is a very it's a wonderful reminder of that, but also of how substantive and procedural laws interact with each other. So that, for example, the burden of proof, how do you distribute the burden of proof on the antitrust authority and on the parties when it becomes a sort of probatio diabolica, so a diabolic burden of proof that is almost either too difficult or impossible to solve, to fulfill, and to discharge. But also, to some extent, I believe that here there are, it is possible for competition authorities to tip the balance on the opposite side, which is on the usage of presumptions, especially of rebuttable presumptions, presuming that some, for example, the unfairness exists. This is something that happens in some other jurisdictions. And without forgetting, though, that there are some jurisdictions that do not accept, as a matter of principle, excessive pricing, like the United States, as an antitrust offense. So in the United States, excessive pricing can be an aspect of an abuse of dominance or monopolization of markets, but is not per se an antitrust offense. So thank you very much again. I think that you posed a number of questions, but also you gave us an incredible amount of solutions related to issues that we are trying to solve in this moment in Kazakhstan as well. For our, as I said before, if you have questions for Dr. Desogus, Claudia Desogus, you can just write them in the chat or keep them for later, and when we will have a Q&A session. So our next speaker is instead an economist. I think that we are now flying to Glasgow, if I'm not mistaken. I think that Simon is still residing there. And we are really super privileged to have Professor Simon Roberts with us today. He's professor of economics at the University of Johannesburg, but he's also been a director at the UK Competition and Market Authority that has been mentioned several times in our previous presentation. So he also has these very unique and useful combination of practical and theoretical skills and knowledge, but also this knowledge of how competition law enforcement and competition policy take place and shape in developing jurisdictions, South Africa, and in Europe and in the UK. So without further ado, Simon, the floor is yours, and thank you very much again for being with us here today. Simon, can you hear us? I think you have a problem, yeah, with your mic because you are unmuted.
Hello?
Hello, perfect.
Good. I think I'd just gone to sleep. The headset had gone to sleep. Okay. Thank you very much for the invitation, and it's a great pleasure to be here today. I also really enjoyed Claudia's presentation, and what I'm going to say, I hope, fits quite nicely alongside that. As Claudia said in the introduction, I worked at the CMA as an economics director for a short period, but my main experience has been actually in South Africa, where I was the chief economist at the Competition Commission from 2006 to 2012, and then I'm an academic there as well. Let me share my screen before I forget. Okay, let me just check it's all there. Is it's sharing full screen?
Yes, absolutely. That's perfect.
Good. Okay, thanks. And as also mentioned that I've got a position just recently at the University College London as well. So I'm I'm not going to talk so much about pharmaceutical specifically, because we agreed that Claudia was going to cover those issues relating to the cases, including the cases of the CMA, which I wasn't involved when I was at the CMA. Instead, what I'm going to do is talk about some of the challenges of excessive pricing, drawing on two case studies, if you like. One is looking at price gouging issues in the UK, drawing from the CMA experience, which I was directly involved in, and then also looking at the experience of South Africa with regard to excessive pricing cases and the evolution of the law there, which really links very closely to these challenges that Claudia was talking about, of the different limbs of the tests and where the onus lies, as well as the nature of the evidence that needs to be brought by the competition authority to prove the case. So I'll talk about that as well. I'm happy to answer any questions as well, of course, afterwards. I think Claudia's already covered these in the introduction, that you know, that most countries have it, but the US doesn't, of course, as we know. And there's a question as to how high the bar should be, because people say, well, look, it's part of the normal entrepreneurial process, and you know, the market mechanism. And there was a question in the chat about this. So under what conditions should it be appropriate to take excessive pricing cases, and if you do, what are the appropriate benchmarks of excessiveness, and what justifications should you take into account? And that second label of justifications is, you know, relates to the issues that were the CMA was challenged with. But I think it's important to recognize that that by its very nature, it is about the competition authority acting as a regulator of last resort, if you like. It's acting as a regulator where there isn't regulation. And so it's in situations where normally the company is an entrenched incumbent, so it doesn't affect entrepreneurs taking decisions normally. It's an entrenched incumbent, and it has the ability to charge high prices precisely because, you know, consumers have got a high willingness to pay. So the exploitation that is taking place is an exploitation of consumers not having alternatives and therefore being willing to pay for that particular product. I think the other thing I want to say at the outset is that it's quite natural that countries would be affected by possible excessive pricing to different extents. If you have a very large market, it's much less likely that you're going to have an entrenched dominant firm in a given industry, particularly a relatively mature industry. Because you have a bigger market, you're likely to have more rivals in that market. If you have a smaller economy, in the South African context, also a developing economy, an industrializing economy, if it's located also, you know, not within a wide free trade area, but separate, then it's much more likely, all else equal, that you're going to have firms with very large market shares that have been entrenched in those markets. So it's quite reasonable to expect that some countries will have more excessive pricing considerations than others. They're more likely to have firms which are quasi-monopolies and are exploiting that position in those markets. So a lot of the debate has been about, you know, these types of excessive pricing cases. Then under COVID-19, so these are cases where the firm would be entrenched in a dominant position and is charging the high prices for a persistent period of time, not for a very short period of time. Then in the context of the COVID pandemic, we had a situation where there were complaints of high prices being charged and exploitative, and what appeared to be exploiting consumers' willingness to pay because these were for essential products, even though for very short periods of time. I think this is where it's interesting because it talks very much to the second limb of the test, which is when would it be justified, and why would it not be justified, even for short periods of time in the context of pandemic. So I think the pandemic has shown how the role of government needs to respond to the context and the particular problems with market workings and market failures. And those lessons, I think, are lessons that we need to take on after the pandemic is over as well. So let me turn to the COVID-19 pandemic. And I'm treating price gouging here as essentially very short-term excessive prices. I'm going to talk about the UK experience, but South Africa actually had a whole lot of price gouging cases as well, which it successfully prosecuted in the competition tribunal. and decisions are written up and available. So in terms of the price gouging that we're talking about exploiting a short-term situation because of the vulnerable situation of consumers. So this talks to where consumers are in a particular situation where they have few good alternatives. In fact, in the both the South African cases and the UK cases where excessive pricing investigations were opened, it's really narrow local markets where people are not able to travel because of restrictions and vulnerability, particularly lower income consumers that are using public transport and don't have their own cars to be able to drive to different shops that might be bigger shops further away. And we're talking about a situation where those consumers are getting taken advantage of at a local level by retail outlets mostly, not by suppliers, but generally by the retail outlets. The counter arguments is, well, you need to incentivize people to come and supply in those local markets. Now, in theory, that's a good in principle. That's it's a reasonable argument. But I mean, it's not as if you're going to have new shops opening up. And in the UK context, actually, a number of types of shops were closed down, and you only had a few outlets that were open, and people were walking just to the ones which were closest to them. So this argument doesn't hold in this circumstance. And so in the emergency context, you have a competition authority being asked to be responsive. And I think this is where it relates to the context of pharmaceuticals in some countries where the competition authority needs to respond to these situations, which may not be the case in another country where maybe it's covered by regulation as well. And so there's a genuine need to respond. We have to think about under what circumstances that response would be appropriate under the heading of an excessive price. So in the UK price gouging complaints, the first thing I think is that the Competition and Markets Authority, the CMA, went out and asked people to lodge complaints when it became obvious that there was this kind of opportunistic behavior going on the part of firms, and was swamped with a large number of complaints and with very, very high price increases. So on the right-hand side, you can see there just the categories of the complaints. And they fell into two broad baskets. One was a set of food products, kind of basic food products, and the second category were things that people needed more of because of the pandemic. So hand sanitizer and masks were the two highest one. Also paracetamol further down the list. And the price increases. So people were asked to. There were thousands of complaints, around about 16,000 complaints altogether. So the CMA developed an online form so people would lodge the price increase, the price before and after the increase, and the store being complained about, and the product specification. And from that, the CMA was able to identify the size of the price increases. And what came out of it was a very, very high price increase of hand sanitizer, 400% median price increase, followed by paracetamol at just over 200%. The food products were around about 100%. Prices had doubled of the food products on a very broad average basis. There's very big differences from place to place. The first thing I think is that the CMA just played a market monitoring role, and by publicizing, going out and writing letters to all the outlets, achieved an outcome. And so achieved an outcome just by doing the assessment and writing back to the outlets. And I think this is important because in the context of excessive pricing, there's been a lot more cases that have been closed following undertakings, not necessarily formal undertakings, that have gone through for prosecution. So when people say that there are not many excessive pricing cases, they're not necessarily taking into account all the cases where the authority has played this kind of market monitoring role, has gone back to the company and said, to what extent is this justified, pure justification, and companies make some adjustments. And this can happen also in the context of market inquiries. So you can use, if you have inquiry powers, an inquiry into a sector to assess the prices, and there may be undertakings, and there's no fault, if you like, there's no contravention of the competition law that's been found, and so I think that's an important approach that an authority can follow. In this context, then almost all of the prices were adjusted, and the CMA played a fairly active role in following up, but didn't launch formal investigations. The one exception was with the hand sanitizer, because those price increases were so large, and it was also that they continued to over a longer period of time. In the other products, it was for a week, 2 weeks, 3 weeks. In hand sanitizer, there was more sustained demand, and higher prices that were being reported over a longer period of time. And this is just for one product, the 50 milliliter bottles, which shows the prices that were being complained of. There are actually 3 prices which are even higher than this, but we're not put on the chart because of it will have an impact on the scale overall. So these are all the complaints. Now, of course, the other thing is that hand sanitizer demand had gone up a lot. So you have a good reason for prices to go up because you've got much higher demand. So this wasn't a case of prices going up at all. This was really about where there was a need to evaluate to what extent were price increases justified, and try to separate out a justified increase in prices from a proper market working. And that relates largely to factors at the production level, from what was happening at the retail level, which is where the retailers were sitting there able to exploit a position over just the consumers in their local area, because those consumers were not able to necessarily walk or travel to a larger outlet, which had a wider range of products. So it's really important to separate out the basis of the exploitation over the consumer from the market factors at the production level, which were leading to higher prices due to higher costs of production. And this was really a critical aspect of this hand sanitizer investigation. So what was a normal market working in this context versus a situation of exploitation? And you can see from the lines, the colored lines, you can see that the prices, the average prices in different types of outlets did go up, and by more than double in most cases, except for the very large national supermarket and chemist chains, the green line at the bottom. These are massive supermarket chains, and they were able to secure very large supplies. The smaller retail outlets were looking to alternative new entrants, sources of imports, for example, which had higher costs, and they passed those costs through into higher prices. But the complaints were many multiples, was of pricing many multiples above that. And that was where the CMA followed up very actively, because these were prices being charged to people in these local areas, and also people who needed to have hand sanitizer because they were needing to go to work on an ongoing basis. So they were key workers doing essential functions, and it was important that they were able to have affordable supplies. So this was the concern. Here, there were a number of cases that were actually opened of excessive pricing, and the CMA did this to compel information, compel the justifications, and ultimately those cases were closed. And the question is whether you see this as a good result or a negative result, that the cases shouldn't have been opened in the first place. The CMA's position is very clear, is that by being able to compel the information from the companies about their costs, and by being able to say, well, we can bring this through to a finding, the companies all adjusted their prices or provided information showing why the price increases were reasonable, and essentially greater confidence in the market was retained. Let me turn to excessive pricing in South Africa. I think this talks to the framing of the tests in legal standards. So South Africa is an interesting case because I think it passed this law in 1998, its Competition Act in 1998, and adopted a lot of what was seen at the time as best practice in terms of the competition standards. And so the United Brands standard was actually embodied in the legislation itself. So it wasn't left for precedent setting decisions to be taken. It was actually embodied in the law, which said that a price was excessive if it bore no reasonable relationship to economic value to the detriment of consumers. What I'm going to show is that embodying it in the law itself was perhaps a mistake, because it led to a huge amount of legal argument around economic value and the ability for lawyers to take to an economist to bring a lot of different arguments around this, which ultimately led to an Amendment Act in 2018, which removed this definition of economic value, because kind of assumes that economics is a science when in actual fact there's a highly contested set of concepts in it. And instead introduced a set of practical considerations which can be considered to differentiate a price from a competitive price. Now, it begs the question of what is a competitive price still, and what may be, on what grounds may be considered to be unreasonably different from that. So a set of kind of quite practical tests, and it's non-exhaustive, and it allows for the competition authority to determine which ones would be most appropriate in which types of situations. Why is it so important in the South African context? The excessive pricing is incredibly important in the South African context because it's very, very concentrated, a very, very concentrated economy with a legacy of state-supported dominant firms, and those state-supported dominant firms had obtained their position under the apartheid racist regime, where essentially there's no base in which they would say this was justified, this was not innovation or risk-taking. And so you had this legacy of large firms which control parts of the economy, and they hadn't obtained this position through this investment or innovation or risk taking. So competition law was seen as an incredibly important tool to address and try and make this market work better. It's been a hard task, I think, and it's still ongoing. So I think that's also important to highlight. And as I said, the market inquiries, which is a new power under the Competition Act amendments that have been brought in, has actually been quite important in terms of addressing pricing issues and getting undertakings from firms, for example, in telecoms about data prices of mobile data. The two main cases in South Africa I'm going to talk about very quickly are related to steel and chemicals, in fact, not pharmaceuticals. But there are situations where firms had this dominant position in flat steel, this ArcelorMittal, but it was the former state-owned steel company in South Africa, which had been acquired by ArcelorMittal. It was called Mittal Steel at the time, and Sasol Chemical Industries for polypropylene. And this was a situation where the prices that were being charged by the companies for local businesses, local customers, were much higher than the prices that they were exporting the product at. And there were very large net exports. So these were companies that were producing around about 50% to 100% more than the local market demanded, and had very, very substantial exports. But they charged local customers the maximum that those customers were willing to pay, and the maximum they were willing to pay was the price that they would have had to pay if they imported the product. So if you were importing the product from Asia, for example, into South Africa with all the port charges and transport charges, you could calculate what that import parity price would be, and you could charge that price to the customer. Meanwhile, you're exporting a large volume of the product, and you're receiving much lower prices for that exported product. So you've got essentially discrimination against local customers taking place. And it has a very, very big impact because these were intermediate industrial products, which then raise the costs of downstream businesses. So this has an effect on downstream employment and investment. So there's a huge impact on the structure of the economy. This is how the cases were brought. There's around 10 years in each of these cases of litigation, and I was involved in both these cases, testified as the expert economist in both these cases. The cases were one in the competition tribunal, which is the court of first instance, if you like, but were overturned by the competition appeal court on different grounds, which were then taken into account in the amendments of the Competition Act. So we can go into it in more detail, but the Mittal case was really about what was the appropriate benchmark price and what was meant by a long-run competitive equilibrium price. Should that be the price that a new investor would need to earn, a new greenfield investor would need to earn when these were companies that had been formerly state-supported? So what costs would be taken into account, and what return on capital would you require? And in the Sasol Chemical Industry case, this was about how much return should be allowed for this particular product, which was a byproduct of fuel refining, and what facts need to be brought, and on the financial analysis side. And essentially, this was a criticism of the financial analysis the commission brought, not the legal or the economic analysis. A lot of details there I could go into if necessary or if interesting. Like I said, I can talk about each of these cases for a lot more if people want, but it's not pharmaceuticals. I think just in conclusion, I think where we ended up in from both of these examples, I think is a kind of trying to strike this balance, but saying that it's very important to be able to take action where consumers are being harmed, including whether those are vulnerable consumers or whether they are important downstream industries. But one needs to be able to bring these different comparators and cost assessments to bear. Where I think I would maybe suggest something a little bit different from what Claudia suggested, is how do you assess the competitive price? So I think there is often a range of competitive counterfactuals based on comparisons across different countries. And I think this is something that's very helpful, very useful to be able to bring in, and a lot can be done through collaboration between authorities. You can see how the Italian authority was more successful than the CMA. So this comparison of what's going on across countries, I think, is a very useful basis, including a comparison of the prices that are being charged and an assessment of whether there are cost differences between the countries. So I think there's a lot of potential for looking at comparators to be able to measure this. And this is an important lesson that's come out of these cases. And then I think in the context of South Africa, certainly I don't know Kazakhstan well, but it would be thinking about how important are these issues to the economy in question, and how this relates to the potential impact and unfairness of that. Clearly, there's other things that can be done, such as and this is not necessarily focused on pharmaceuticals, but thinking about industries more generally, about promoting greater rivalry. But one's often faced with a particular case in question, needs to deal with that case. So it's not a kind of easy answer, but engaging with regulators, better regulation, for example, in the CMA's phenytoin case, it was seen as a regulatory gap, if you like, and now it's getting regulated. And so being brought into the regulatory net might be the longer term solution after a case has been concluded. Let me finish off there, and I look forward to the discussion. Thanks very much again.
Oh, thank you very much, Simon. Indeed, I'm again taking so many notes today. But first and foremost, let me congratulate you on your new appointment. I didn't know that you've got any appointment at the University College London. I believe you wrote UCL. Is it the UCL in London? Okay, perfect. Because there is also the University of Louvain that has the same UCL logo, so I was not sure.
Sorry, yes, it's the Institute for Innovation and Public Purpose at the University College London. Yeah, the institute headed by Marina Mazzucato.
Oh, okay, yeah. So I know it's during my relatively short experience, almost a stunt at the UCL. I've been there just for a little over 1 year. I had the privilege of being for a little while also visiting the center. So fantastic. Mariana Mazzucato just established it when I left. So it's great, really. Many congress and. Very well deserved, I gotta say, and so we are. I'm actually not also surprised about some of the like overlapping opinions, but also contrasts and differences in the opinions of our speakers. Because in particular, I like very much, that the fact that they have both our first two speakers have both talked about enforcement balance, comparators and different approaches, harm to economy, regulatory solutions, but also the fact that Claudia is a lawyer while someone is an economist, and obviously they have different views on counterfactuals. For us lawyers, a counterfactual looks more like a well-functioning crystal ball that actually doesn't work that well, because we are not able probably to see anything in this crystal ball. But that's the beauty also of competition, that puts together different professionality skills that have to be somehow that have to work together. But I think that's a great lesson for us is also to think about how price gouging very often takes place in markets. So the fact that there is that these might have multiple clauses, that is causes that is not only demand and offer, but also price transmission and overall competitiveness of the markets, which is absolutely a great point. And this also explains why some jurisdictions have an allergic reaction to concepts such as unfairness and excessive pricing, such as the US. Although, as Simon said at the beginning of his presentation, there are federal antitrust laws that address exactly the problem of price gouging. So while at state laws, while at federal level in the US there is no excessive price, antitrust violation in case of excessive pricing, some state laws do include also price gouging. So thank you very much. And for our next speaker, we fly all the way to Japan because Professor Masako Wakuri is with us today. Thank you very much, Masako, for accepting our invitation. She has incredible experience in a number of industries related to competition law, but she's mostly, she's a professor of anti-monopoly law at Kyoto University, and she has an extensive experience in analyzing competition laws, especially in Asian countries, but she has been comparing that the competition law of Asian countries, and in particular Japan, with the competition law of Europe and the United States for a very long time as well. And she is also a consultant to the JFTC, the Japanese Fair Trade Commission. And she has, lately she's been working also on a book on competition law in the pharmaceutical sector. So, but I would like her to introduce her work and possibly also the results of this work. So again, thank you very much, Masako, for accepting our invitation, and the floor is yours.
Thank you. It's such a generous introduction of myself. Thank you. Let me share my, is this?
Yes, but we can see the, yeah, now it's better. Perfect.
Am I doing okay? Yeah.
Yeah, I can see that now. Yeah.
Is it like slideshow now? Yeah.
Better. Yeah.
Good. Okay. Thank you so much. I'm honored to have the opportunity to give this presentation here. Having heard all these fascinating, thrilling presentations, I'm going back to the cartel problem. I'm so happy. I was actually so happy that the Kazakhstan Competition Authority had a case, the cartel case in the pharmaceutical. It was the first. Congratulations.
Yeah, thank you very much.
I was so happy. Thank you. Yeah, good. So, right. So, amongst many issues that we have to deal with in relation to COVID-19 and the pharmaceutical sector, my focus is on cartel regulation. Then, right, it's such a fundamental thing. But so the Competition Authority of Japan, the Japan Fair Trade Commission, does not refer to cartels on its website, specifically created for COVID-19, but that does not mean that the issue is minor. Well, a bit like Kazakhstan, I guess, no Japanese pharmaceutical company has succeeded in developing a COVID-19 vaccine, actually, and Japanese government is buying a lot from foreign pharmaceutical companies. Then this chart shows the development, clinical trial, and approval stages for the various vaccines, and only Pfizer has obtained approval so far in Japan. Now, over time, latecomer vaccine will also be approved, and I would like to see active and fair competition amongst them. Then in the context of COVID-19, the government is also buying various goods and services, including other types of drugs, testing services, contact tracing services, help desk services, and personal protective equipment. They are all important, in fact, and the last thing that we would like to see is providers digging the bed and fixing the prices for unfair gains under such circumstances. And in fact, the JFTC uncovered bid rigging for road restoration work after the Great East Japan earthquake in 2011. That was very immoral and truly outrageous. I hope that our cartel laws are effective enough to deter such collusion to begin with. However, if companies are colluding, I would like the competition authorities to detect and stop them as soon as possible. So fortunately, with regards to PPE, the JFTC took measures against the bid riggers some years ago. So I hope that no collusion has existed in PPE market since then. Then in the pharmaceutical sector, on the other hand, I've been hearing about cartels since 2019. So this is a case list. Well, please note that like in Europe and the US, like Japanese people are like always doing the cartels and nobody, so the Japanese people are good at colluding. So this is always, it's actually not. Although the JFTC investigates several cartels every year, the last time it issues an order in relation to drugs, pharmaceutical, was more than a decade ago. And furthermore, in more than 70 years JFTC's history, actually, Japan competition is like third, what to say? So after Canada, US, Japan had competition. So it's quite a long time. And in more than 70 years of the JFTC history, it was filed this one, like criminal accusation. In total, the JFTC has done this in whole sector, across the sector, like only around 20 cases. So normally JFTC resolve the cases through administrative measure, like cease and desist order and civil fine payment order. But in this case, JFTC chose to go for the criminal sanction because it took, regarded it so serious. So it is remarkable. And this is last year, and the first case ever. Criminal accusation was filed by the JFTC in pharmaceutical sector. So how serious this was? Like in this case, 4 major wholesaler companies rigged a bid at the public procurement process organized by the Kuosh Government Institute called the JCO. The JCO was buying drugs for its 57 hospitals. So the inflated cartel must have damaged not only hospitals and patients, but also insurers and taxpayers. Just to be cautious, just as like caveat, the JCO collective purchase system, nothing to do with the monopoly power. So it's not. So no, there is no buying power issue here. The JCO collective purchase system exists to cut costs. And the bid rigging here frustrate such a name. It's buying for its 57 hospitals, while in Japan there are more than 8,000 hospitals in the whole country. So next one is the this is the next case relates to the one particular drug where a manufacturer and its competitor fixed the price. So the scale is minor. Smaller, relatively speaking, although it's still bad. So these cartels on its own is harmful because the high prices set and those inhibit access to drug. But a close look, however, clarifies the even more harmful nature of these cartels. So like in many countries, the free market system, public and private insurance system, public procurement, and government regulation all play a part in the pharmaceutical sector in Japan. And government oversight in Japan focuses on this, like the services and the products covered by the public insurance system. Then when we look at the supply chain, this is a drug supply chain. Pharmaceutical company sells the drug to a wholesaler, the food wholesaler then sell them onto hospitals and the pharmacies. And the payment made by the hospitals and the pharmacies are reimbursed by insurers. This is since the national public insurance system exists. Then the amount of the reimbursement is essentially determined by the government according to National Health Insurance Drug Price List. So not NHS, NHI list. So this part is regulated. This price is regulated, while these parts are not. So these prices are set freely, like through price negotiation. Then how the government so this part NHI price, only here the amount of the reimbursement is decided by the government. So how it's decided? So when new drug first makes entry to this NHI drug price list, thorough examination is conducted by the government, considering the cost and considering the risk and the tax and everything and the worth value. And then after first entry, government like regulate revise the price list to lower them basically. So first, when as a new drug, that price is calculated by considering those costs and everything. But once made the entry, after this, the government revised the price list with referring to the actual price set by manufacturer and wholesaler. So, and that revision, price revision, takes place every 2 years. And the government conducts a survey first, and based on the result, they adjust this price. So naturally, because this has got to be the largest, this amount has to be largest enough to cover these prices. So then these are set. So this is the largest, naturally. Otherwise, they wouldn't be they wouldn't use them. Then these are set by price negotiation. So it's up to like free market system is used. So these are lower naturally. So government conduct a survey and revise and adjust price list. Referring to this price means that the price is going to be lower, like reduced, like every reduction, every survey, every revision. Then here, what the cartel does is that if the cartelist, these manufacturers, the wholesalers, successfully keeps the price high, this price high, up to like NHI price list, they can manipulate this price reduction system, price regulation system. So that is how. So this image is a bit like obviously like extreme, but just for simplicity, let us assume that cartelists manage to keep the actual price at the NHI price list level. Then there is no price decrease when the government revises the list, and the pharmaceutical companies and or wholesalers maintain a large profit margin. This is an example of how a cartel manipulates the regulatory system and harms the healthcare system altogether. So there's another way to rig the system. Paramount bed case related to the hospital bed. Tokyo government hosted a public tender to buy beds for their hospitals. Well, hospital beds are more complicated and have more functionalities than the beds we use at home. So Paramount is a leading company in this kind of products. Tokyo government wanted to have more competition at the public procurement stage, naturally, to buy them at a lower price. Then what the Paramount did? Paramount successfully convinced the Tokyo government officials to adopt certain designs or specifications, they became requirements that bed suppliers needed to meet. The specification included a certain design that was covered by intellectual property held by Paramount, which no other bed manufacturers could reproduce. So when Paramount was talking to the Tokyo government officials, the Paramount actually omitted that information. So the Tokyo government officials didn't know it. And then as a result, Paramount excluded other bed manufacturers from the tendering process. Then Paramount also orchestrated bid rigging amongst the bed stores and inflated the price even further. So this is bed, but although that case was involved in hospital beds, I suspect that anti-competitive tactics such as this can easily take place in the pharmaceutical sectors. In relation to the drug doctor or hospital can be like the Tokyo government officials, or the pharmaceutical companies can be like Paramount. So the pharmaceutical company may manipulate a doctor's choice in favor of on its brand. So these cases illustrate that government involvement in the supply system, either through public procurement or price regulation, creates a space for businesses to manipulate and rig the system. So here, the cartel prohibition is imperative and to deter and correct such practices. There may be anti-corruption law, but please note that there was no bribery involved in any of these TFTC cases. Neither Tokyo government officials nor JCO officials did not receive any financial gains from suppliers, as far as I'm aware of. So although eradicating corruption is very important, that's not sufficient. And another point that I would like to make is that there are leniency applications in all three of the cartel cases I referred to earlier. So in this context, let us not forget that the regulatory body, like Ministry of Health in Japan, does not have the capacity to investigate suspicious cases on its own. They do not have the human resources, procedural rules, and know-how, or cartel investigation requires special expertise and procedures. So thus the competition authority can complement and play an extremely important role in maintaining the natural healthcare system. And Japanese cases also demonstrate, I think, the importance of the very basic competition rules, such as cartel prohibition. That is very bad. There's no controversy. Cartel is bad. It's so simple, but it can be vital. So depending on the design of the regulatory system and the healthcare system, I think how to calculate the price list, price of drugs, and how the public procurement system is designed, depending on these, the space, how the system is rigged and manipulated are different, I think. But that's my belief that there's always the space for manipulation, and there's always a place for the competition authority to play a part. So of course, there are many other issues that we need to consider. For instance, that perhaps Japan may wish to examine why it has been so slow to develop vaccines. It may be because of the market structure or trading practices. So to explore this further, I'm actually, as Claudio kindly said, writing a book on the competition policy and law in the pharmaceutical sector together with the Kobe University colleagues in Japan. But for now, I would like to stress again the importance of the competition authorities and their activities in the area of cartel regulation. Thank you.
Thank you very much indeed, Masako. Your presentation was perfectly fitting and matching with the previous presentations, by the way. And I would like to say that this is my own doing, but it's not actually. So thank you very much, because it gave us lots of interesting insights on how competition law And in particular, anti-competitive agreements and bid rigging can be used in the pharmaceutical sector, while before we have been mainly looking at cases of excessive pricing due to abuses. So this was extremely interesting also from the perspective of a country that is trying to grapple also with the problem of competition law as a means to actually help anti-corruption laws work better, right? So well, by eliminating the chronism that exists in certain sectors of the economy, and this is also something that competition law can do. Obviously, not alone. As you mentioned, we need also anti-corruption laws and an overall regulatory framework that allows us to reach those objectives. And I also like very much your references to this unique combination in Japan between industrial policy, price regulation, and competition, which is for me extremely interesting because it's a different use of regulation and competition than what we see in many other jurisdictions. So thank you very much again. I would have 100 questions for all of you, but I cannot abuse my role of moderator. So thank you very much again, Masako. And our last speaker, last but not least, obviously, is Alexey Ivanov. He's the director of the HSC Higher School of Economics, Skolkovo Institute for Law and Development, and the BRICS Competition Law and Policy Center. Alexey is a colleague and a friend. He's been applying and working in the pharmaceutical sector as well as in many other sectors, and he's been analyzing competition law enforcement both in Eurasia, Russia, and BRICS countries and Europe for a pretty long time. His center is by far the most active in Eurasia, but I think that it competes pretty well also with European and international other centers. So without further ado, Alexey, the floor is yours, and thank you very much, really, for accepting our invitation. Please, the floor is yours.
Thank you, Claudio. Thank you for this great flattering, I would say, introduction. And thank you, Marat, for having me for this discussion. It's really connecting East and West, as I see it's coming from the name. And so you confirm that it's really the way the modern antitrust works. It's actually quite exciting because for quite a long period of time, antitrust was pretty much Western thing. And now it's becoming more and more global thing. And what we're missing is actually some sort of global regulatory regime probably for antitrust. And I hope one day we can discuss something related to really like global tackling of these problems of really global scale. And if you don't mind, I try to do a brief presentation as well, sharing my screen. Can you see it?
Yes, but it's still not in presentation. Okay.
How is it now?
It's not okay. Now it's full screen. Perfect.
I want to briefly cover the topic of pandemic. Pandemic-related antitrust problems in a very particular segment of it is a vaccine development and how this vaccine development could be an issue for different regulatory regimes like antitrust and intellectual property rights. Because I think all of those, they have a lot of in common in terms of protecting consumer welfare and increasing consumer welfare. And both regimes actually, in my perception, have shown some form of flaws and actually failed to help us, to help global society of human kind to prosper and develop resistance to the pandemic. And as a confirmation of this, we're still meeting online. Although I remember, Claudio, you promised me several times that we will meet in Almaty, especially until the season is not over. I mean, skiing season, because Almaty, and this is second of advertising, is the best ski resort in Eurasia, or at least one of those. It's a really great place, and I hope we can meet on offline very soon. So
you're always welcome.
Yeah, problem of vaccine development and competition regime. As we all know, currently we are in the race, in the vaccine race, which is to a certain extent resembling some sort of arm race. The different countries, different blocks of countries, different groups within countries trying to develop their vaccine, to trade on their terms, to negotiate, to use the bargaining power. All sort of actually crazy stuff is happening with regard to development of vaccine, because when you see such an existential threat as pandemic actually expose on us, you always have somebody who want to, to benefit out of it. We have a saying in Russian that for some war is a trouble, for others is a mother. In Russian it's like кому война, кому мать родна, means basically that some guys are always benefiting on when you have some sort of large scale disaster. And actually humanity, it's not the first time the humanity is actually facing this type of this large scale disaster, this large scale pandemic. For instance, influenza or virus was widespreading in late 60s, 70s, and was actually quite serious disease. And probably you know the previous pandemic of Spanish flu was caused by this influenza virus in the beginning of 20th century, was very devastating story. So humanity developed some sort of mechanisms, a framework to deal with this type of pandemic, to quickly develop both vaccines and treatments. And actually at the level of United Nations, as the World Health Organization, it was established a special, very inclusive and very cooperatory platform to develop different forms of responses, healthcare responses to the influenza virus. And it was very successful enterprise. It is still very successful enterprise. So currently every year, representatives of different countries, more than 120 countries, meeting at this platform at the level of World Health Organization and contribute to this joint, basically, research and development project with their data, with their funds, with their expertise, and collectively developed what we know actually seasonal flu vaccine, which is distributed then among different countries. And basically we can say that the pandemic, or at least influence of influenza, is tamed. So the governments and businesses of different countries managed to create this collective mechanism, which works very well. It's totally different in terms of response was a reaction to the current pandemic of coronavirus. We saw a lot of unilateralism, actually exclusive dealing rather than inclusive relations. We saw a lot of this type of mercantile approach when you try to close your borders and try to to be first in developing of this vaccine. As an outcome, we see a huge expectation in rise of corporate profits of those few companies which managed to market their vaccines now. And on the one side, on the other hand, according to the World Bank, we're expecting a massive increase in poverty in the world. So global inequality and level of poverty in number of countries, actually very wide spectrum of countries covering all basically regions of the world, they're going to experience this massive increase in social instability, poverty, and other negative implications of this pandemic. And the reasons why we see this striking difference between the approach to influenza pandemic and coronavirus pandemic is basically could be related to a number of factors, but in a sphere which we're professionals in competition law and related innovation regulatory mechanisms, we can indicate at least 3 elements. And one is basically lack of global sharing, data sharing, research sharing, technology sharing framework. And some researchers like Stiglitz and Dean Baker trace it to the changes the global, let's say, global governance system experienced back in 80s, when we saw a rise in neoliberal thinking, neoliberal mentality, which actually created a lot of, I would say, as you know, in this Hollywood movie called Greed, you know, Geki. You remember this movie when he was saying some, you know, great words about the role of greed in developing of capitalist society. So the greed was unleashed to such extent that basically corporate profits and corporate self-interest became so much, you know, unrestrained, unconstrained by any form of regulatory influence on global level. So basically we bet too much on corporate self-interest, and we ended up instead of international cooperation in some form of heavy vaccine race. Another thing is actually proliferation of IPR regime, IPR protection. As you all know, after WTO establishment in 1995, TRIPS regime was actually spread around the world, and number of countries introduced IPR protections they didn't have before, and patents and patent protection became to a large extent over reaction to the problems basically TRIPS supposed to address. And we see overprotection of intellectual property, we see different forms of abuses, and as an outcome we see the very harsh reaction at the WTO framework, in the WTO framework, to some initiatives brought by India and South Africa just recently to waive IPR protection for vaccines, so that vaccines could be much more freely distributed. And we see this as a kind of, you know, a form of thinking about stimulation of innovation, which is now dominating most of the international fora like WTO and United Nations. And the third topic is competition, how competition is now organized on the global level. We do lack some sort of global regime for competition on global scale, so that when you, within your national borders, you have some sort of, you know, supervision from competition authorities, you constantly under some sort of, you know, counterbalancing influence from consumers who can sue you in the courts, you have all forms of, you know, competition law enforcement within national domain. But on international level, when you're coming to such, you know, big questions, big issues like vaccines against the pandemic, you totally ungoverned. It's a totally unregulated field where the most drastic forms of competition taking place, where competition is turning from, you know, normal capitalist exercise when, you know, in its fair form, you know, when you have competition on the merits and all these good things, but it's actually turning into some sort of warlike exercise, which is bringing with it a lot of negative implications for global welfare. So currently we see massive imbalances, many massive kind of dysfunctionalities in distribution of vaccines. According to the Nature magazine, we see that some countries stockpiles vaccines, you know, to cover 9 times of their populations, and some, including actually big economies like Brazil or Mexico, they really lacking access. And probably one of the reasons is this regulatory framework they're living in So it's a kind of if you win like all, or if you're losing, you kind of dying. So it's pretty harsh choice for some of the countries, which actually showing how unbalanced this regulatory framework is. Yeah. So one of the response on national level to this type of imbalances, what we observe now, because on the global level, on WTO level, on level of World Health Organization, we couldn't reach some form of inclusive participatory solution. So a lot of countries they decided to use emergency instruments to counterbalance power of global pharmaceutical companies, and they turned to compulsory licensing and basically converted from emergency to sort of ordinary mechanism to manage this health crisis. We see actually on this map is just few countries which introduced recently during the pandemic period compulsory licensing mechanisms. They didn't use this mechanism before much, but during the pandemic they were persuaded by the general public, and in the political discussions they decided, okay, we have to do something, and the least they wanted to do is using compulsory licensing. So we have Emergency Response Act on the at the Canadian level. They have this act recently enacted. It says it's expired, but actually it's prolonged recently, so they still keep it going. So they want to use compulsory licensing for healthcare purposes in administrative manner. So basically using it through different decisions made by administrative body with some supervision from the court, but still it's administrative mechanism. Same goes to European Union. Actually, we have also Israel, which issued a compulsory licensing to Kaletra medicine, which is used as antivirus medicine. We have France, who also introduced this emergency law. So they called it like emergency law with basically same type of purpose. In Russia, and that's actually interesting point I wanted to bring your attention to. Not all the countries, they have legal regimes which are providing this mechanism for the governments and for the general public, like compulsory licensing mechanism. For instance, in Russia, we're missing this mechanism. We don't have it. We do not have compulsory licensing instruments for public goods. So, which is very, very strange for the country which is coming from socialist background, from commons background. So it's like pendulum swing. You're starting from one extreme, you end up with another extreme rather than somewhere in the middle. So now we are kind of in balancing process with our pendulum going back, but in principle, Russia doesn't have it. So only during this pandemic, we introduced a law. No, it actually was introduced early on, but only during pandemic it was passed by the State Duma, by our parliament, with introductions of heavy criticism coming from pharmaceutical industry, from big pharma. Of course, they don't want it to happen. But actually, it's now becoming less and less possible for them to sell same type of argument that you have to protect intellectual property despite of any type of social negative consequences it can bring. So we now in a process of discussion of this amendment into Russian law, and I hope it will be done very soon, so then Russia can join this group of countries which now are imposing compulsory licensing restrictions on pharmaceutical companies. But still, I think it's not a good solution when all national authorities reserved, to this type of national response. You have a global problem, global challenge. Corporations on corporate level did not decided not to cooperate, but stuck with some sort of warlike approach in the race to development and then distribution of the vaccine. But then you have on the government's level also, instead of more cooperatory framework which could be introduced, and I think the 1 year we are still in this pandemic, it was enough time to develop some sort of cooperative inclusive framework. We didn't even start building anything. So there is no even like a treaty proposed or another mechanism like influenza development. And so it shows that trajectory of the global development is much more like unilateral, hostile, this type of Hobbesian, like Hobbes described it, war, everyone against everyone type of global legal order we're more like facing. And I want to end with the words from Antonio Guterres, who was saying that international cooperation clearly failed in the context of this pandemic. My final point is that it would be very strange for some countries who do not have this mechanism of compulsory licensing and some sort of flexibility strips actually in first. To keep it going as usual. So we would see more, I would say, delusion of intellectual property protection regime. We would see more fragmentation happening in the world, more like national responses rather than international responses. And it's quite, I would say, quite detrimental path, in a sense that probably we would see deconstruction of existing institutions and more like hostile interactions happening between the states and between economic agents within the states. So it's quite bad for the state of competition in the world, and I don't think that's the way we have to head to. So thank you very much for your attention. Happy to take any questions. I hope I didn't take much time. Thank you.
It was perfect, actually. I say thank you so much. And actually, I'm very happy that you gave us this larger and bigger picture on using this example of the vaccines, the market for anti-COVID-19 vaccines. And here, I like very much actually the fact that you compared these what existed in many of the negotiations that were taking place before under mostly the multilateral platforms and methods that were used, especially with the WTO, but not only. While now we observe mainly these bilateral preferential agreements that probably show also the limits, the inherent limits to the principle of allocative efficiency, and also what you said to capitalism as was envisaged with the 80s neoliberal revolution. You mentioned Gordon Gekko, but I think that he was taking inspiration from the famous quote from Milton Friedman that was something like, is there any society that doesn't run on greed, right? So obviously his question was a rhetorical one, but that tells a lot of the kind of concept and the type of markets that we contributed to build, right? That led us to this moment. And also your call for more international, for international competition law enforcement, that, as far as I know so far, goes mostly in the direction of more cooperation. But I think that you want to take it a step further than just cooperation and coordination. And I think that our guests can ask questions on these. But that was also very interesting, especially in relation to issues such as licensing and the balance between intellectual property and incentives to innovation. So enforcing intellectual property or enforcing more competition law, where do you strike the balance between fairness and efficiency and incentives to innovation? That's another very complex issue that needs very thorough analysis. But I don't want to take too much time, so I believe that we have, so thank you very much again, Alexei. And I believe that we have, if our guests have a few minutes left to stay with us, perhaps we could take a few questions. I have already one question. I have one question that was shared in the chat that was mostly regarding how to find the how to draw the line between excessive pricing and non-excessive pricing and non-unfair pricing, if I well remember. Yes. So to reinterpret the question, I think that this was a question mostly addressed to our first two speakers. So if either Claudia, that I know that has to leave us in a few minutes because she has another meeting, or Simon want to talk about in a nutshell, they want to tell us about the different benchmarking approaches or comparators approaches. Claudia?
Yes.
Okay.
Well, the presentation of the methodologies applied in the two cases was just an example to provide you with the flavor of the difficulty of in drawing this line precisely, and that's all a matter of methodology, which leaves these open questions that I indicated in at the end. So far, our light fire is, at least in Europe, for National Competition Authority as well as the Commission, the light fire is the united brand test, and therefore we are, unless we follow another complete different methodology, such as a cross-country comparison, if we follow to look at the costs, if we choose to look at the cost and in comparison with the prices, or rather the prices in comparison with the cost, then we have to follow this two-limb test. So of course, we are especially in Europe, we all adopted free market rule, and obviously free entrepreneurship is attached to free pricing. This is just in general, okay, because we have also to consider that there are regulated industries where free entrepreneurship is somehow contained by regulation. This is the case also in the pharmaceutical market, but as we saw, there are some loopholes in the regulation, and that's why you have a scope, you have a room for ex-post intervention from the competition authorities. And exactly to avoid a situation where you invade the space of free entrepreneurship, you have to stick to a very rigid methodology and robust methodology in order to understand, first of all, whether the price applied is excessive and whether it's also unfair. Remember that it's not enough when you find that the price is excessive to find a violation of Article 102, letter A. So it's like two filters that have to be passed in order to consider a pricing policy to be illegitimate, which and the standard of proof is quite high. Okay. So I hope I answered the question.
Okay, thank you very much. This is the answer that my students hate the most, which is it's complicated and it depends. But that's the answer that you deserve, especially if you are studying a complex issue. And I actually, this is a very good example that, thank you, Claudia, I would like to take to my to class. And because the fact that there are different benchmarks and comparators models that can be used at the same time, and there is a two-stage test that has to be applied, and that can change from case to case, right? Is extremely interesting. Okay, thank you very much. Simon probably wanted to add something to this.
So I can just add, I mean, I think from an economics point of view, using international comparisons is quite important. And I think this goes to a point Alexei also made, which is there's a huge potential for improved international collaboration. There's a real gap actually in terms of the multilateral system around competition and looking at markets in terms of working authorities working together, as well as looking at global rules. You know, you have the same countries, so you have different countries trying to address the problems of the same companies. And yet the countries are not working together. Pharmaceuticals is one good example. So you can actually, you know, if you're willing to do these benchmarks and you find there's these very big differences, you can really put the onus back on the companies to say, why are you charging a price which is two or three times the price in another country? Are there particular costs? And maybe that other country has got a better information system, they have got more knowledge, obviously. I think this is very important for developing countries as well. They should be able to benefit from the knowledge that has been generated in other countries. Then you have to correct for different cost features, of course. You have to take this into account. But where you're talking about a basic benchmark where the price is a multiple of where it is in another country, this is a really good starting point. And it really has an opportunity to place the onus on the companies. The South African amendment under excessive pricing does exactly that. It says if you use some basic comparisons of what would be a competitive price, then you, if there's a prima facie case that there's that this price looks different, then the company has the onus to justify. So the fairness test still has to be completed. Maybe they had to make some particular investment in the country in question, which justifies it. Maybe there's some other reason which justifies it, but they have those facts. There's an information asymmetry here, and they have that knowledge. But you have to do the assessment, the initial assessment, and say, here's the price that we are concerned about, and these are benchmarks of what we think is a competitive price. An example I want to give from South Africa, and the mobile data charges, which were very important for people who were not connected to fixed line telecoms under COVID, really critical for students, were very high, seen as quite high. And the same companies, these were Vodacom and which is a subsidiary of Vodafone and MTN, they are operating in many other countries. And why is the infrastructure different in South Africa compared to other countries, including other countries just over, you know, one border in Southern Africa? And you have these benchmarks and say, well, this is the price you're charging for 1 gig of data here. This is the price there. This is a big difference. You tell us why it's justified. And if they can't come up with a good justification, then you should adjust the price downwards. There was no penalty here and no finding. It was about, it was actually under an inquiry. But I think it is a process which is very useful, and you can resolve an issue quite quickly of this nature. This pricing under mobile data was also charged to consumers who were buying small volumes of data, low-income consumers, because people who were wealthy consumers who could buy large end, they had different prices. But why was there any cost difference between buying 15 gigabytes of data, 1 gigabyte of data, or 100 megabytes of data? The company had to say what the cost difference is. There isn't really one. So this was anti-poor pricing. And then you see, you know, the company is faced with an anti-poor pricing charge. Of course, they care about their reputation. I think there's a lot of opportunities here for authorities to be proactive with these comparators and then shift the onus, if you like, onto the companies. Even if, as I said, it may be a settlement at the end of the day and not a finding with an admission of with guilt.
Oh, perfect. I think Alexei wants to add something.
Yeah, if you don't mind, just a little bit, I want to double a little bit on what Simon said. I think it's very important, these presumptions, how they work. You know, in the question we saw, it was more like presumptions that there is a free freedom for enterprise to keep prices as they basically wish. And then authorities have to prove that it's unfair, it's extortion, or other, negative things. But I think in some cases we have to switch this presumption, and burden of proof should be switched to the companies. For instance, we see two countries, Russia and Kazakhstan, and very closely interrelated, part of the economic union of trade zone, neighbors, similar type of level of income. American company Gilead sells sofosbuvir, a medicine against hepatitis C, very widespread in EurAsia disease, unfortunately, to Russia 100 times more expensive than to Kazakhstan. So it's unexplainable in terms of any type of logistical cost or something. And the reason is only they considered Kazakhstan as a developing country and Russia as developed or whatever, so in different basket of countries. So they provided Kazakhstan with a license, which is a kind of compulsory license, much more loosed in terms of pricing and terms. So Kazakhstan could enjoy prices 100 times literally, less than Russian patients. And I can see if you have this type of case, you should not have a long investigation about some sort of strategy behind this, some sort of incentives, what was the decision making, how was most done. I think it's pretty straightforward. If company doesn't have a very clear, explicit explanation why it has to raise to keep these prices so different, so they should its behavior should be found unlawful. And in the cases which Claudio so brilliantly explained us, we can see that it was a corporate strategy behind Aspen and Flynn to buy product which is becoming off patent, but still dominating because of therapeutic characteristics and its positioning within the healthcare system. So they understood that they have a probably short window of opportunity to extort from consumers monopolistic price. And that's why they paid quite substantial price for this drug to the originator's company. So whether we have to encourage this type of behavior and consider it as free enterprise, consider it as a normal business, or it's immediately raising red flag, and we have to say, okay, this is not about business, it's about extortion. And then you explain why it's not extortion. So if we do not change these presumptions, if we not shift, burden of proof, we would constantly in chasing several hares at the same time. It would be impossible to accomplish this task, because you would have a zillion of moving targets with very limited resources on the side of authorities. So probably even catching one would let others to go below the radars and escape. So probably this type of expedient mechanisms of reaction to this type of behavior could be put in place. I'm just maybe a little bit speculating, but I think it's very important, this kind of prima facie approach to this type of price differences.
Yeah, and that's extremely useful indeed.
Can I comment?
Yeah, absolutely, Claudia. Please jump in.
Sorry. Can you hear me well? My connection is not really great in this moment.
Yeah.
I just wanted to comment on the across-country comparison, because I'm speaking from the perspective of the enforcer in this moment. Okay, it would be great to resort to this methodology, because it is much easier. It is much easier to do that than to dig into the balance sheet of a pharmaceutical companies, because we all know that they are black boxes and they don't really reveal their costs. So to understand what it's really the cost they undertook, they incur in to develop a drug, it's really a difficult task. So it would be perfect to just refer to another price. The problem is, I would love to do that, but there are two limitations. First of all, we are speaking of companies that are dominant, otherwise we wouldn't care of them, of their conduct, right? But why they are dominant most of the time? And it is because their drugs are essential. There is no other product in the market or even in other markets. So it's already difficult to make a comparison. If you have a densely densely populated therapeutic area where you have more than a drug targeting a certain disease, then your task is more difficult. But most of the time, you don't have.
Oh, no, I think that we have lost Claudia, unfortunately. I hope she will be able to reconnect. There you go, she's back. Claudia, can you hear us?
Sorry,
It's
I
okay.
can, yes. Yes, and the second thing that I wanted to say, even when you have a product and you want to look at the price, this is at least for Europe, okay? This is like a Europe specific, what I'm about to say. If you want to look at the price of that drug in the other European markets, you might not have really useful insights. Why? Because from an institutional and a regulation point of view, although we belong to the European Union, we are very different. And you really wonder why, but this is the result of this. You have very different prices for the same product. We have very different prices with respect to Germany, for example. Germany is not a good comparison for us. We would never refer to German markets because it's a country that typically and traditionally allows for very high prices, which our regulator cannot really negotiate, cannot really bear. So a cross-country comparison for drugs is difficult and sometimes meaningless. Third limitation, what if the price that you are using as a benchmark that is charged in another country is also excessive and unfair? Is also inflated by an abusive conduct. Like Aspen implemented a pan-European strategy and went to the other national regulators and obtained already the increase of the price there. So what if we had referred to those prices? They were already inflated. So that's why we could, all these three reasons are behind the fact that we chose to dig into the cost of the company rather than
Claudia, okay, I think that we have lost the very last part of you.
But I'm done.
Okay.
No, I don't want to steal too much of your time.
No, but actually it was extremely interesting because that's what I hope for, some constructive disagreements on how different approaches to a heavily regulated market naturally have. Like there is no one silver bullet, and I think that we all agree on that. And that would allow you to solve all problems in pharmaceutical markets. And it's extremely interesting to see how, probably some procedural devices can help, as we agreed upon before, in order to solve some of these complex issues, such as a wise usage of presumptions, but that have to be real rebuttable presumptions and not rebuttable presumptions that are under disguise because they become impossible to rebut, thus they become rules of procedure rather than presumptions. And but as for the rest, you know, where every jurisdiction has to find and has to look for a possible ideal solution. That's obviously ideal cannot be, because it will change over time. Do we have any other question for our speakers? I think that we are running out of time, but if there is any other question.
I just had a comment, Claudio.
Please.
Of course, I'd like to thank all the speakers, and like especially just following up on what Claudia said. It's exactly what we're trying to wrap our minds about at the moment as a newly established agency, and learning from the experience of from doing actually and the current experience we have with the healthcare system. We have a lot of questions regarding methodology and cross-border referencing and reference pricing, as we call it here. We still have our doubts, so it was extremely useful for us to hear different approaches, and the Aspen case is obviously, Claudia mentioned, is exemplary of how we can import inflated prices on our borders, and this is something that we saw throughout different. It was extremely helpful. But in general, there were a lot of really great points raised by different speakers. For example, Simon Roberts has mentioned this size of the economy argument, which is, again, we can confirm from our experience as an emerging market, small, closed economy, and very distant from the access to the sea. So international trade issues are bypassing us, and we do see a lot of private monopolies and state monopolies across sectors, and hence the idea that we have been established as an agency. So it's an economic security issue for Kazakhstan, and our president has raised the bar for competition by establishing this agency where we work. And the idea is that competition in Kazakhstan, it became a national idea in his address. So for a small and close country like ours, it's especially challenging. So, well, but we are ready to, happy to share as a newly established jurisdiction competition sphere. We're happy to share cases. And yes, it was mentioned before that it's extremely important to share practical cases across different continents, not only in EurAsia, but and we heard a lot of great cases in Japan. So I'm very thankful to all of you for your inputs, especially my colleagues have, I think, have had good feedback, because frankly speaking, we had difficulty in actually exchanging, accessing materials on the specific cases in Kazakhstan. So it was actually difficult. I hope this is not the last time we exchange and speak to each other. I'll be very happy to follow up on those issues. Thank you, Claudia, for organizing it and for your support. Hopefully we can follow up on the many issues before. Simon mentioned that he works in the UCL. I'm reading this book on mission economy by Maria Mazzucato. Is very fascinating. I worked in the innovation space before, and I actually wrote her a couple of weeks ago, inviting her to Kazakhstan after this pandemic ends to speak to our prime minister, and she's very involved in policy making, and something that we could actually follow up after. So I would like again to thank all the speakers. It was extremely helpful to us. So yes, let's keep in touch.
Yes, thank you.
And thank you very much, Marat, also for these near interest of the Antitrust Authority, by the way, of Kazakhstan in research, as you can see, and development not only of the enforcement of competition law, but also of ideas throughout the country and Central Asia as well, because for those of you that don't know very well Central Asia, Kazakhstan is the major player, probably economy in Central Asia, and is together with Russia is one of the most important players in EurAsia in general.
And good skiing as well.
Yeah, and for skiing is Almaty in particular. For skiing is fantastic. So hopefully next time we can meet, we can all meet here in Almaty. That would be my pleasure, but also my honor to have you all here. And so thank you very much again to Marat and the Antitrust Authority, but also to all our guests for giving us for participating today to this. Today and for speaking to us in this webinar. Thanks very much. I really appreciate that, and I really hope to see you all soon in person. Again, thanks also on behalf of the ECLID Center and of KIMAP University, obviously, and hope to see you soon. Goodbye then. Bye-bye.
Goodbye. Goodbye, everybody. Thank you very much.
Thank you very much.
Thank you.
Bye.
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 Bye then.